Oyez, oyez, oyez. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Kraft. Good morning, everyone. This is day 2 of the Tennessee Court of Criminal Appeals here in Nashville, and we have several cases on the docket today. Let me introduce my 2 colleagues who are on this panel. Judge Robert L. Holloway Jr. from Columbia and Judge Ross Dyer from Memphis, Tennessee. My name's Robert Wiedemeyer. I live here in Nashville, Tennessee, and we are obviously not in the courtroom. We're conducting this via Zoom, and we are grateful to Ms. Kraft and Jim Hivner, our clerk, and particularly the AOC and their staff, including Nick Morgan, for helping us do this technologically speaking. We're all very anxious to get back into the courtroom, and hopefully that'll happen soon. But in the meantime, this technology has been great to get us get these cases argued and disposed of. That being said, we'll conduct things as closely as possible to the courtroom setting, which basically means we'll have each side will have 20 minutes. If the appellant wishes to reserve some rebuttal time, and I understand, Mr. Ames, you'd like to have 5 minutes, is that right?
That is correct, Your Honor.
Okay, so you'll have 15 minutes, and I'll try to keep up with the time for you, saving your 5 minutes. Now, of course, you can use some of that 5 minutes, but just, it'll be gone after that. So we have read the briefs on these cases, and so we are prepared to that extent. We have not been assigned the records at this point, but I think we're ready to proceed. I think I've covered my preliminary remarks. Thank you, Madam Clerk. If you'll be kind enough to call the first case today.
State of Tennessee versus Marcus Willingham.
All right, Mr. Ames, you can proceed with your argument.
Thank you. Good morning, Your Honors, and may it please the court. My name is Daniel Ames, and I represent the appellant, Mr. Marcus Willingham. And as Your Honors already noted, I'm reserving 5 minutes for rebuttal this morning. Your Honors, I believe this is an important case, just given the issue that's at play here in this case, one of the key issues. And one of those key issues to be resolved by this court today, or to be reviewed by this court today, is whether the evidence of the use of adult pornography is admissible when not related to the underlying alleged criminal act. And so, Your Honors, the answer to that question is based on the applicable Tennessee rules of evidence, and this court's precedent is simply no, that it's not admissible. And as Your Honors know, Tennessee Rule of Evidence 102 provides that the purpose for the Tennessee Rules of Evidence is to secure the just, speedy, and inexpensive determination of proceedings, and they are meant to be construed to meet those purposes. And as Your Honors are aware from reading our briefs, Mr. Willingham was convicted for rape of a child under Tennessee Code Annotated 3913-522 and soliciting sexual exploitation of a minor under Tennessee Code Annotated 3913-529. So first, Your Honors, the trial court abused its discretion in allowing the evidence regarding Mr. Willingham's possession of adult pornography to be admitted as evidence. And the reason this came up is because the alleged victim testified that she was shown a specific pornographic video involving a woman wearing a black dress with silver sparkles on it. And she was clear in those details, and I believe those details are important. She testified further that this was the only video she was ever shown. And again, she specifically stated the woman was wearing a black dress with silver sparkles. In fact, this detail was so important, the Murfreesboro Police Department, when it directed its digital analysts to review and to search the materials found on Mr. Willingham's devices, they directed them to search for any porn videos with black female in black dress with sparkles. So they were clear. They thought it was important that those details were there. And again, the video was not found in Mr. Willingham's possession. It was not one of the videos recovered on any of the devices. And so the evidence that came in regarding his use of pornography just should not have been admitted. And for the first reason is that it's not relevant. As Tennessee Rule of Evidence 401 provides, Relevant evidence is any evidence that has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And here, his possession of different pornography, different than the one described by the victim, is just not relevant. It doesn't make it more or less likely that she was shown video A when video A was never discovered or found or located on his devices. So his use of pornography, his possession of pornography is just not relevant as it relates to the charges brought before him, because it does not match the description of that the victim described.
Well, can I ask you, Mr. Ames,
Yes.
why is it not relevant to the fact that the victim said that he showed her pornography on his phone? And why does the fact that they couldn't find the one in the black dress with the sparkles not go to the weight of her testimony rather than the admissibility of some pornography that she said after she said he showed her pornography on her phone?
Yes, Your Honor. That's a good question. I believe that the reason it's still not relevant, and yes, it could go to the weight of the evidence, but the reason it's still not relevant is just because of the fact that this court and the other and the higher courts in Tennessee have all ruled that pornography use has such a prejudicial effect that it shouldn't come in unless its probative value outweighs that prejudicial effect. So the fact that it may have gone to weight simply also just, it doesn't change the fact that it would still have such a great prejudicial effect that its probative value does not outweigh that prejudicial effect. Instead, Your Honors, this was simply, as I stated in my brief, this would be similar to a case where the only witness to the case testifies that the man broke into a bank with a red hammer and he's pulled over and has a yellow hammer in his car. The possession of the yellow hammer doesn't mean that he had the red hammer. So it shouldn't come in. It's not relevant. The possession of the yellow hammer doesn't change that the red hammer was used. So it just doesn't affect the actual underlying charges in this case. And as I began to get into, even if this court were to determine that it is relevant, it's his possession of pornography is simply, the evidence of that is more prejudicial than probative. And as the Court of Appeals has already held, the admissibility of evidence concerning a defendant's use of pornography is governed by Tennessee Rule of Evidence 404B. In fact, the Tennessee Supreme Court has found that pornography use has such prejudicial potential that it should be addressed through Rule 404B. And again, the Supreme Court took it even one step further by finding that caution is especially warranted in trials for sex crimes because a jury may infer from a defendant's use of pornography that the defendant had the propensity to engage in other morally questionable sexual behaviors. That's State versus Clark. And while the use of adult pornography is not a crime, many people still consider it to be a moral wrong. And that's why the courts have cautioned and been careful about allowing evidence of pornography use to just come in when it's not underlying situation. In fact, I think State versus Mccary is pretty good on this point. And in that case, there were some similar types of charges that were at play. And the defendant was found with some magazines and some videotapes in his briefcase. And the court said that while the magazines and videotapes that each victim could identify as that the defendant kept in his briefcase would be relevant and not so prejudicial as to preclude admission into evidence, the same conclusion cannot be reached with regard to those magazines and videotapes which could not be identified by either victim. Other than serving as propensity evidence, which would typically be inadmissible, those items would have little probative value and would likely engender substantial prejudice. Thus, the items should have been excluded. And that's where I believe we are today, is that simply if the video that she had identified was found, certainly that might, absent some other maybe potential evidentiary arguments, that might be more relevant. It would certainly be more relevant. Here, his possession of different items that were not the ones identified as the court has already held, should not be admitted, as they're not actually going to the conduct that was alleged to have occurred. As I stated, if the video matching the description by the alleged victim was present, that might be relevant. However, the video that doesn't match the description is simply propensity evidence, which is inadmissible and only engenders substantial prejudice. And as an aside note, briefly, it's the use of the adult pornography. Pornography use has such prejudicial potential. It's not that they have to show the actual items and materials to the jury for prejudice to occur. It's just the use and evidence of his use of those that has the prejudicial potential in this case. So that's why we would argue, Mr. Willingham argues that his possession of adult pornography should have been excluded because it was more prejudicial than probative. And this court's already made it clear that when it's only being used for propensity evidence, it's inadmissible and it should be excluded. And we would argue, and Mr. Willingham argues that it's not a harmless error, because here the jury could be inflamed because it doesn't matter if they're shown the evidence. It has such prejudicial potential. The courts have made that so clear that it is not a harmless error. And in Clark, a case where this court found that it was a harmless error, there was substantial other evidence. I mean, the defendant was found with T-shirts with bodily fluids on them. He was found with other items and other, multiple testimonies and other items there. Here, it's the testimony of the alleged victim and then the evidence of his pornography use. This pornography use barely clears the harmless error, does not clear the harmless error rule, because it was clearly prejudicial in this case. So for that reason, we would ask that his conviction be set aside. But even still, secondarily, the other argument would be that the evidence was not legally sufficient for a rational trier of fact to find the defendant guilty of the accused crimes. In fact, as I stated, if this court were to find that the evidence of pornography use was not admissible and would to strike that and should have stricken that from the record or from, it shouldn't have been admitted, then the only evidence really would be the testimony of the victim, who had numerous inconsistencies throughout time. And so there's not a legally sufficient basis for a rational trier of fact to find him guilty. In fact, she admitted to changing her testimony, and that's in the transcript, volume 1, page 256, lines 1 through 7. She admitted she was mistaken when she recalled the number of incidents. She testified that she's made false accusations against her brother and involving similar types of acts and conducts, and that those occurred before the alleged allegations against Mr. Willingham in this case. Therefore, she must have had some knowledge of these things somehow before even the allegations made against Mr. Willingham, because she had already made a false accusation along these lines prior to any of those things occurred. She had numerous inconsistencies as it relates to those points. And then secondarily, as it relates to the other charged crime of soliciting exploitation of a minor through electronic means, the prejudicial effect of the pornography use that was admitted in this case simply made it where the only other evidence, again, would be her testimony, which was not sufficient, as, again, she had numerous inconsistencies when testifying. And even if the court were to find that maybe the trial court should not have admitted the pornography use, but that it's harmless error, the cumulative effect of all these things is that it's a harmful error, and it goes against Mr. Willingham's ability to have a full and fair trial on this matter, as it relates to the fact that the only evidence would be a witness with inconsistent testimony, as well as the evidence of the pornography use, which is, again, such a prejudicial matter that this court has routinely found it to be more prejudicial than probative as it relates to those things. And in fact, the admission of the evidence more probably than not affected the verdict or resulted in prejudice to the judicial process in this case. And so for these reasons, Mr. Willingham requests that the court find there to be harmful error and that the evidence of his pornography use should not have been admitted at the trial in this case, and remand these proceedings to the trial court for further proceedings.
All
Thank
right. Yeah, thank you, Mr. Ames. You still have your rebuttal time. So General Watkins, good morning, sir. Are you ready to proceed?
Yes, Your Honor. Thank you very much. Good morning, everyone. May it please the court. Austin Watkins here on behalf of the state of Tennessee. The defendant's convictions for rape of a child and sexual exploitation of a minor should be affirmed because the child victim's testimony was sufficient evidence of his guilt, and the trial court properly admitted evidence of his possession of adult pornography. Your Honor, just briefly to kind of cover the sufficiency evidence before moving in, or the sufficiency question before talking about the 404B issue. Just a real quick recap of the facts here. The victim was the defendant's biological daughter. She testified about numerous instances of sexual abuse during which the defendant would bring her into his bedroom in the middle of the night while her stepmother was at work. She testified to multiple acts of oral, anal penetration of various forms. And then eventually this abuse was brought to light when a note that she'd written to her stepmother was found on the school bus. And so what is clear in Tennessee law is that the testimony of a victim alone is enough to constitute legally sufficient evidence for the purposes of the Constitution. And here the defendant kind of points to a couple of inconsistencies in the victim's testimony about how many times a certain type of act happened, and then a little bit of inconsistency about whether or not she was in trouble based on something that had happened at school a few weeks earlier. At the time she'd written a note that kind of prompted the investigation. But none of those minor inconsistencies, Your Honors, rise to the level of rendering this victim patently unbelievable, which is essentially what is required for a defendant to show in order to overcome the Jackson versus Virginia standard for constitutional sufficiency. And we just don't have that here. Frankly, Your Honors, I mean, we've got a very young victim who was 10 years old at the time of trial, and she testified very specifically about what happened to her, impressively, I think. And generally, her testimony was corroborated, right? So no one saw exactly these acts that happened, but the fact that, for example, her mother had to work the night shift, that was corroborated. The fact that the defendant had access to her room easily without having to pass her stepbrother's room was corroborated based on the layout of their home. The fact that she was able to describe the nature of the personal lubricant that was in the defendant's master bedroom corroborated her testimony that she was in there, and probably for unsavory purposes. And so, Your Honors, the jury was entitled to hear this testimony to evaluate the credibility of this victim and everyone else who testified at trial and make a credibility determination and decide what was the truth here. It's a quintessential jury task. And so under facts of this case, Your Honor, Your Honors, this court should affirm because there was more than sufficient evidence based on this victim's testimony. And then moving into this 404B issue, Your Honors, the trial court properly admitted testimony about this adult pornography possession that was found on the defendant's external hard drive because the purpose was that it was being offered for was not for propensity. It was being offered to corroborate the victim's testimony on the charges of sexual exploitation of a minor. So those two sexual exploitation counts were based on him showing her pornography as he abused her. And she testified about that specifically, 2 different instances of him using a video to essentially coach her into what he wanted her to do. And so the parties agree on what the law is for this issue, other than the state's noted in its brief that it's arguable whether or not this is actually a 404B issue, but assuming that it is, what we disagree about is the nature of this pornography. And so the state's position is that this pornography that was testified to, it could have been the pornography that constituted the basis of these charges. It was not other pornography. And so, what happened is the lead detective executed this search warrant based on the victim's forensic interview description of the videos she was shown. And the lead detective reviewed the videos that were found and found a couple of videos specifically that were very, very consistent with the victim's description. And the way that the lead detective admitted, now I can't say for certain that these, that these are the videos that she was shown, and I can't say they are 100% consistent with the description she gave, but they are mostly consistent in that I found videos with labeled as daddy-daughter, which is consistent with her description of her impression being that there was a teenager with her father in the videos. The detective found the same type of sexual acts that were described by the victim in these videos. And when it came down to this one specific fact where the victim said the lady was wearing a black dress with silver sparkles on it, the lead detective said, well, I found videos with a woman of the same race wearing a black dress. I wouldn't say that there were sparkles on those dresses, but I did find some videos with sparkly things in the videos. And so, the defendant says, well, you've got to have 100% match of the facts, or this pornography is going to be some other pornography and it's only being offered for propensity purposes. But, Your Honors, the sufficiency of the match, whether there was enough of, specificities in these videos consistent with her description, essentially kind of goes to the weight of the evidence, in that the jury was entitled to decide whether it thought that the state had proven that those were the videos she was shown or not. And so, the defendant's counsel was able to cross-examine the lead detective on the nature of the search and did so very thoroughly. Was also able to cross-examine the victim about what she saw in the videos. And so when you look at it that way, that these videos were mostly consistent with what she described and were being offered to show, hey, she says that she was shown videos. Here are videos that are possibly could be what she was describing. That's corroboration of the specific offense. It is not being offered under 404B to say, hey, he had pornography, therefore it makes sense that he may have abused this child. It was being specifically offered to corroborate this. And frankly, Your Honors, if they had found pornography and none of it really matched what she had described, it'd be a whole different situation too, where if the state was kind of trying to backdoor it in under the argument that it's making now, but it was very clear that there's no chance the pornography that they found was what she saw, then it would be a whole different analysis. But it's not. These videos were very, very similar to what she was describing. And so it was proper for the state to introduce those videos for the purpose of saying, hey, we think this is probably what he showed her. It's consistent with that. And ultimately, all you need to do is believe what she's telling you anyway, right? The videos themselves are not the only evidence of what she's testifying to. She described what he showed her at trial, and that in and of itself would have been, sufficient to prove up these charges of the sexual exploitation of a minor. And so, Your Honors, without belaboring the point, the state's position is that the trial court, which made proper 404B findings and held a jury out hearing on this, did not abuse its discretion in determining that these videos were largely consistent with those described by the victim. They were being offered for a non-propensity purpose to show that the defendant had the means and opportunity to commit the offenses of sexual exploitation of a minor by showing her these videos. And so if there are any questions about the facts or about the laws, Your Honors, I'm happy to address those quickly. And if not, then the state would ask you to affirm the admission of this evidence and to uphold the judgments for sufficiency. Thank you, Your Honors.
Thank you, General Watkins. Mr. Ames, you've got your 5 minutes of rebuttal. If you wish to use some or all of that time, you can go right ahead.
Thank you, Your Honors, just briefly. And I'll start out. I'm just going to focus mainly on the evidence of the use of pornography in this case. The victim clearly testified, and this is an exact quote, she was wearing a black dress with silver sparkles on it when she described the woman in the video. When she was asked if there was multiple videos, she said it would be the same one. So she clearly testified that there was only one video that was shown. Whether it was shown to her multiple times is a whole other thing, but there was only one video that was shown to her. and it had a black woman wearing a black dress with silver sparkles on it. And even the state admitted in their response to the defendant's motion in limine that we cannot say definitively that the detectives found the exact video or video clip described by the child among those in Mr. Willingham's possession. And further, when the detective was questioned about it, she said, "I did not see any black dresses with sparkles on them." So the detective would testify clearly that there was no video with the black dress with silver sparkles, that the state even corroborated that they can't confirm that that was the exact video. So simply, the state's position really is a could have been. They're just, and it's our position that they are trying to backdoor his use of pornography in as propensity evidence against Mr. Willingham in this case. They'd say, well, it's similar to the sexual act. Well, it's pornography. Pornography is the video of sexual acts. I mean, most pornography would be similar to the sexual acts described then, just given the fact that it is by its nature a video of a sexual act. And again, the sufficiency of the match may go to the weight of the evidence, but this court's made it clear that the pornography use warrants extreme caution. Its prejudicial effect can greatly and easily outweigh the probative value that it can have. And then that's what's happened in this case, whether it's not mostly consistent when it doesn't match. If it doesn't match, it doesn't match. I mean, it's simple as that. If it's not what she described, if her testimony is strong enough that we have to believe that every detail that was made, then every detail is relevant. And if the video was a black woman wearing a black dress with silver sparkles, if that's not found, then the others are his use of pornography is simply not relevant. And it can't just go to
the victim.
Yes.
How old was the victim?
At the time of the trial, she was 10 years old.
So under 10 at the time of the offenses, obviously.
Yes.
Well, I mean, we have child witnesses. Let's just say child witnesses all the time who, their recollection of events that took place, traumatic events that took place, are not always 100% consistent. And so why would this be any different? If there's videos that have a woman in a black dress or black clothing, why isn't that enough consistency to allow it in? And then two, what did the trial court instruct as far as how they can review this evidence? I mean, the trial court didn't say, hey, I'm assuming, give an instruction, say, hey, we're letting all this pornography in, and you can consider it however you want. I would assume he gave some sort of instruction of, you can't use these videos as proof that he actually committed the crime. It is proof as propensity to commit the crime. It is proof to corroborate or not corroborate the witness's testimony, right?
Yes, I briefly, before I answer that question, I believe I may be just about out of time. Is it okay if I answer that question fully?
Yeah, certainly. Go right ahead. You're okay.
Okay, thank you. Yes, and so I believe what's relevant to answer your question would be to look at the State versus Mccary case, which was a similar type of factual scenario wherein there was pornography found on the defendant or in the defendant's possession. There was accusations of incidents involving minors. And in that case, the court ended up finding that only those which were the ones identified by the victims would be admissible, and that the others would not be admissible, as they were just there to engender substantial prejudice against the defendant. And so I believe that's what goes to answer your question, is that the courts found before in Mccary that the other items, the other ones that are not the ones described by or identified by the victim, are simply just others that are propensity evidence and would likely engender substantial prejudice in this case. Thank you.
All right. Thank you, Mr. Ames and General Watkins. This case was well briefed and well argued. We appreciate that. we'll take it under advisement and issue an opinion as soon as possible. And that concludes this case. So court will be in recess. Ms. Kraft, if you'll adjourn us until the next case. Thank you.
This Honorable Court of Tennessee is now in recess.